Welcome to The Explainer. Today, we are getting into the weeds on a really fascinating part of the U.S. tax code. It's a loophole, and a big one. We're going to unpack how a rule that was originally designed to help civil rights plaintiffs has morphed into a huge tax break for almost any kind of lawsuit between an employee and their employer. So picture this, right? You win a $1 million sexual harassment lawsuit. I mean, that's a huge victory. But then your lawyer takes their 40% cut, the IRS takes its share, and suddenly you could be left with just this, $200,000. How on earth is that possible? And believe me, for decades, this wasn't just some crazy hypothetical. It was a real devastating tax trap called phantom income. It made this exact scenario a reality for so many people who won their cases. I mean, can you imagine? You're literally being taxed on money that went straight into your lawyer's pocket? Okay, so how are we going to break this down? First, we'll dig into that phantom income problem. Then we'll look at the fix Congress created and the surprising loophole that makes it so powerful. After that, we'll walk through how to actually claim this deduction on your taxes and wrap up with a modern-day complication that could threaten the whole thing. All right, first things first. To really get why the current law is such a big deal, we have to go back and understand the fundamental unfairness that was baked into the tax code for years. So, the heart of the issue was this thing called phantom income. Here's how it worked. The IRS said that plaintiffs had to report the entire gross settlement as their own income. Yeah, even the 30 or 40% that went straight to their lawyer. So you, the plaintiff, were getting a tax bill for money you literally never even saw. And this wasn't just, some aggressive stance by the IRS. This got cemented by the Supreme Court itself in a 2005 case, Commissioner v. Banks. The court was crystal clear. Those contingent legal fees, they are part of the plaintiff's gross income, period. And just like that, the phantom income problem had the full force of law behind it. Okay, so thankfully, Congress was paying attention. They looked at this and saw the injustice. They recognized that even if the bank's ruling was legally correct, the outcome for plaintiffs was just deeply unfair. So they stepped in and passed a legislative fix. The solution actually came just before the bank's decision was handed down inside the American Jobs Creation Act of 2004. This act introduced a brand new section to the tax code, Internal Revenue Code Section 62A20, and it was designed for one specific purpose, to fix this phantom income trap. Now, the real genius here, and this is absolutely crucial, is the type of deduction Congress created. It's what's called an above-the-line deduction. And let me tell you, that's a total game changer. It means you get the full benefit no matter what your other deductions are. It reduces your adjusted gross income, or AGI, before all the other complicated tax stuff, like the alternative minimum tax, even has a chance to mess with it. So what's the end result? Well, for cases that qualify, this whole provision basically creates a wash. The plaintiff does what Banks says, they report the full $1 million in gross income. But they then get to take a $400,000 above-the-line deduction for those legal fees. The net result? They're only taxed on the $600,000 they actually pocketed. Problem solved, right? Well, not so fast. And this brings us to the real heart of our explainer today. The true power of this law is all in the details, specifically in the definition of what cases actually qualify. You see, the law says it's for claims of unlawful discrimination, but it's the tax code's super broad definition of that term where things get really, really interesting. So if you actually pull up the text of IRC Section 62E, the first 17 subsections are pretty much what you'd expect. You've got your classic civil rights and federal labor laws, the Civil Rights Act, the ADA, the Age Discrimination Act, they're all in there. It even explicitly includes claims under the Fair Labor Standards Act, for stuff like unpaid overtime. No surprises so far. But then you hit subsection E18, and this thing is a monster. It's a massive catch-all provision that just blows the doors wide open. It expands the definition to cover claims under any law, we're talking federal, state, or even local, that regulates, and I'm quoting here, any aspect of the employment relationship. And that phrase changes everything. Suddenly, this deduction isn't just for discrimination in the way we usually think about it, race, gender, disability. No, it now potentially covers almost any legal fight that happens between an employer and an employee. So what does that actually mean? Well, it means the legal fees for a simple wrongful termination case. Deductible, a basic breach of an employment contract. Deductible, a fight over an unpaid bonus. You guessed it, deductible, above the line. I mean, think about it. These are mostly economic disputes, not what you'd call classic civil rights violations. But they all get covered because they regulate that employment relationship. And listen, this isn't just some clever lawyer's theory. The IRS itself has actually confirmed this super broad interpretation. In a private letter ruling, the agency gave the green light for the deduction in a case that involved breach of contract, breach of fiduciary duty, and even fraud. And their reasoning? You guessed it. In the IRS's own words, it was because those claims regulated the employment relationship. Okay, so now we know just how incredibly broad this deduction is. Let's get practical. How does a taxpayer actually go about claiming it on their tax return?
It's actually a pretty simple two-step process, and it all happens on Schedule 1 of your Form 1040. Step 1, you report the full gross taxable settlement as income. You'll put that on line 8Z, which is for other income. Step 2, in Part 2 of that same form, you take the offsetting deduction on the line specifically for this. That's line 24H. And boom, that creates that nice clean wash we were talking about.
Okay, but what if things get a little more complicated? What if a settlement has both taxable and non-taxable money in it? For instance, damages you get for a physical injury are tax-free, but punitive damages are always taxable. Well, in that case, you have to allocate your legal fees. So look at this example. You have a $10 million settlement, but only half of it, the $5 million in punitive damages, is taxable. That means you can only deduct the portion of the legal fees that applies to that taxable income. So 50% of the $4 million fee, which comes out to $2 million, is deductible. You have to be careful to only deduct the fees that are linked to the taxable part of the award. So for years, this system worked pretty well. It did its job, preventing that awful phantom income problem in employment cases. But then, a law passed back in 2017 threw a major wrench in the works, creating a really troubling complication, especially for the exact kind of cases that this whole thing was supposed to fix in the first place. I'm talking about Internal Revenue Code, Section 162Q. It's unofficially known as the Harvey Weinstein Tax. And what it says is that you can't take a tax deduction for any settlement payments or attorney's fees that are related to sexual harassment or sexual abuse if that settlement is subject to a non-disclosure agreement, an NDA. Now, at first glance, this seems aimed squarely at the person paying the settlement, right? The idea is to stop companies from getting a tax write-off for paying hush money. But the problem is the law's wording. It's vague. It says under this chapter, and that has created this really dangerous ambiguity. The big question is, does it just stop the defendant's deduction, or does it also wipe out the plaintiff's absolutely critical above-the-line deduction, the one under Section 62A20? Because if it does apply to the plaintiff, well, it brings that phantom income nightmare right back from the dead, specifically for sexual harassment victims who sign an NDA. We are literally right back at square one, that horrifying scenario from the beginning. You win $1 million, you pay your lawyer, and then you have to pay taxes on your lawyer's fee, leaving you with just a tiny fraction of what you won. And so this leaves us with a huge and so far totally unanswered question for the Treasury and for tax professionals. Did Congress really intend for the Harvey Weinstein tax to punish both the person paying the settlement and the victim just because there's an NDA involved? What does this massive uncertainty mean for the future of civil rights cases? It's a critical issue, and we desperately need some clarity.